A good deal of what people call the skill of the criminal practitioner is, number one, creativity, solving old problems in new ways, and number two, recognizing a piece of good luck when it occurs. Very often, some of my most effective cross-examinations have not been effective because of the careful planning that I always put into a cross-examination, but in the ability to seize upon a moment when a witness said something that neither the prosecutor nor I had expected. From 1972 to the present time, I have been practicing all forms of criminal law, both state and federal. Both my partner, Dan, and I share the backgrounds as prosecutors. To have been in that life so that you really have not only an understanding, but an inner feel for how that works. This has a great advantage over criminal defense lawyers who did not have the good fortune to be a prosecutor earlier in life. There can be no such thing really in a serious case of a lawyer who is just a negotiator, because part of the negotiation is the perceived ability by the prosecutor of the defense lawyer to be able to launch an attack and a defense if necessary. When I give my opening statement, as far as I'm concerned, the jury has to believe me. They cannot see me as some neutral advocate who has been paid to represent somebody who's just an indictment number sitting at a table. When I speak to the jury in my opening statement, I expect them to believe me. Thus, when we get to the actual evidence in the case, as a practical matter, as far as I'm concerned, all the jury is doing is confirming the evidence that I gave them on my opening statement. That is the art of the practice of criminal law.